taking the time to come here or to present from remotely their thoughts on this very, very special international human rights instrument. The European Social Charter is a key component of the European Bill of Human Rights. And this is in itself a good reason for students and scholars to get it, to know it in depth. At the same time, it is somehow less well known, less explored as compared to its more prominent counterpart, prominent in terms of visibility at least, that is the European Convention on Human Rights. Why we have two different instruments regulating general catalogs of human rights in Europe? Well, it would be a long discussion here. Let's say that also at the UN level we have the same dichotomy. And probably one of the main reasons for this dichotomy lies in the different control mechanisms that were thought originally for social rights and for civil and political rights at the international level. With time, the system of the Charter has changed. The Social Charter I refer, not only I'm referring to the European Social Charter, it's not an instrument that is whose respect is supervised by an international court, but the European Committee of Social Rights is in some respects at least akin to an international court, and it works in very specific ways which nonetheless manage to shape also domestic legal orders. And looking at how technically and de facto this shaping takes form is, I think, what is at the core of today's discussion. So learning to understand how this instrument works, I think, is a key to understanding also how international law works more generally and how the interaction between international and domestic law works. This is one of the many reasons why I'm very eager to listen to our speakers today, and I hope that also our students will find it a very interesting and rewarding experience. Thank you very much. Thank you, Silvia, for organizing this very nice conference and also for participating in the experience of the Advanced Legal Clinic and the Moot Court that is somehow linked to today's conference. I won't take any further time. Thank you again, and I look forward to listening to all of you. Sorry, yes.
Yeah, thank you, Serena, for this introduction. So as Serena said just 1 minute ago, this is the scientific event that opened the Moot Court organized since last year by the RACS network, or Annex in English. And last year it was organized in Brussels by Professor Van Drogenbroek, that will be with us tomorrow. And we were really, really happy and we enjoyed a lot the Brussels experience. So for me, in particular, it was the first Moot Court in which I participated as a trainer together with Ilaria Quironi. And our team, beside enjoying the Moot Court, won the competition. So in the end, we discovered the prize, and the prize was to organize this year the Moot Court. So I just prevented people that decided to participate this year. The prize will be the organization of the next Moot Court. Anyway, we were really happy because this year we have some more teams that enrolled to the competition. So we have l'Université Paris-Saclay, the University of Aix-Laurent in Budapest, Prague University in Brussels, l'Université de Saint-Louis in Brussels, l'Université Jean Moulin in Troyes, l'Université di Nantes, University Aristotle, University of Thessaloniki, l'Université de Sorbonne-Paris-Nord, University of Ferrara, l'Université de Rouen-Normandie, l'Université de Panthéon-Sorbonne-Paris 1, and the University of Valencia. So we have 12 teams, and so we will start soon to organize to prepare the collective complaint and the defense of the government. I just remind all the team that on the 21st of November the case will be released, so soon the scientific committee will meet in order to prepare the case and to present the case to all of you. So when we discuss about the topic for this first scientific event, that opened our moot court, for us it was very, very clear the necessity to discuss about the effectiveness of the European Social Charter and the decision of the European Committee of the Social Rights. Why? Because we have the impression that the more the Charter is important, the less is considered in the national legal order. And in particular, as a labor lawyer, I would like to mention what is happening in Italy and France. So we had two very, very important decisions of the committee on the dismissal, the French and the Italian dismissal law. And both these decisions have not changed the national legislation. So basically the Italian and the French government did not consider this decision as a reason to change the national legislation. And besides, some national court, in particular the Cour de Cassation in France, adapted their jurisprudence in order to resist to the decision of the committee. So this is not a good sign. I think this should be discussed, this attitude should be discussed, because as Serena said, the European Social Charter is considered the European Social Constitution. It's a key document for the protection of social rights in Europe. So before giving the floor to our first two speakers, I would like just to thank two persons without whom this seminar wouldn't have been possible, Ilaria Quironi and Carlotta Rambaldi. Carlotta was one of the members of the team that last year won the competition, the moot court, so we asked her to be present this year in order to help the Ferrara team and to help us in the organization. And I would just to ask to all the participants if it's fine for you to record the seminar, because we want to record the seminar. Okay, also the participant online. Basically, the idea to register the seminar is because we want to have the registration available online for all the teams that will participate in the moot court. Okay, so if we all agree with the registration, then we can start our discussion, and we want to start our discussion from the committee perspective. And this is the reason why we invited two members of the Secretariat of the Council of Europe, the Department of the Social Rights of the Council of Europe, Gerard Thun and Nino Cipashvili. Sorry. Okay, sorry for the pronunciation. I don't know who you will start. So thank you very much for coming and for having accepted our invitation.
Thank you. It's a real pleasure to be here today among friends of the Social Charter and to represent the Secretariat of the Committee of Social Rights, together with my colleague. I would like first to thank the organizer, Professor Borelli, and her colleagues to create this opportunity to discuss in the beautiful town of Ferrara. The As you know, the multiple crises that we've been going through on our continent in the last few years have brought to the fore the importance of social rights even more than before, and their enjoyment by all, and particularly the most vulnerable in our societies, as they are more likely to experience difficulties in accessing basic social rights. As you know, the Charter is a unique instrument that protects a vast panoply of rights that prove instrumental in the current difficult context that we're going through, going from the right to health, the right to fair working conditions, access to social welfare, the right to protection against poverty, and the right to housing, just to name a few. In order to ensure that state parties respect their commitments to Charter rights, there is a sophisticated monitoring mechanism that has developed, through the years has developed more than what it was intended initially. The two main strands, as you know, is first conclusions on the conformity with all provisions of the Charter accepted by state parties, and decisions on collective complaints based on grievances connected to specific rights raised by social partners and NGOs. Together, they should not be seen as completely separate. Together, they form a coherent corpus of case law, because conclusions influence the case law of under collective complaints and vice versa. My colleague will give an outline of the monitoring mechanism and the two branches I just mentioned before I take back the floor to say a few words about the impact of a reform package that has been adopted by the Committee of Ministers of the Council of Europe in September in order to improve the effectiveness of the implementation of the Charter by states parties, which will link very nicely with the theme of this conference. So now I pass the floor to Nino.
So Nino has a presentation. We should share maybe the screen. Yes, I think it's in here. Yeah. Okay. Where is the presentation? I have it on my USB key if you want. Yes. Okay. But I will move here then to use the mouse. Maybe my glasses too. Okay, it's fine. I think it's fine, yes. Okay. Hello, everybody. I'm really pleased. It's my pleasure, my honor to be here in this beautiful city and in this university. And to take part in this initiative. I've heard from colleagues who participated in the moot court competition last year that they found it so rewarding. So we're also looking forward to a similar and maybe even better experience this year. Let me just briefly tell you about the current system that we have for the monitoring of the European Social Charter by the European Committee of Social Rights. As you heard, Gerald said, there are plenty of reforms underway. So this will the system, the monitoring system, might change very soon. But let me just focus on the system that we have now. So as you know, I'm sure you know a lot about the Social Charter, and let me just very briefly say that, as was already also mentioned today, it's a treaty that sometimes it's even called the Social Constitution of Europe, and it currently is fundamental social rights as a counterpart of the European Convention on Human Rights. And the Social Charter is based on three values. Human dignity, meaning that human dignity should be respected of any person in the territory. That equality, hence the prohibition of discrimination, that's Article E of the Charter, which is a horizontal provision in the same way as Article 14 of the Convention. So equality means that societies should be such as to allow for differences between people and to eliminate all forms of discrimination. And then solidarity, which is a very important value in general for social rights, because as we know, social security, social assistance
systems are based on the concept of solidarity. And also solidarity also means that helping those who cannot help themselves. This is also a very important dimension and a value. So here we have two systems, as I said, and I'm sure you know a lot about it. So let me just focus on each of them and also talk about the follow-up that is given to the decisions and conclusions of the European Committee of Social Rights. That could be something interesting for you. So let me just start with the reporting procedure. As you know, this procedure is still the main procedure because it's mandatory for all now 42 states parties. Now we have 42, yes, states parties. So states parties to this charter. So that means the reporting procedure means that the provisions of the charter are divided currently into 4 thematic groups. And this will maybe change in the future, but right now this is the system we have. So states parties are required, are obliged to provide a national report on 1 thematic group each year. For instance, this year we're dealing with labor rights. That's a thematic group. And the conclusions will be published in January. So last year, and I will also focus later on what happened last year, because we already have conclusions and some follow-up. So last year, the thematic group was health, social security, and social assistance. So states send the national reports, and then we also receive comments from social partners. These are trade unions, employers' organizations, and also local NGOs or human rights institutions, equality bodies. These comments are obviously very important for the European Committee of Social Rights to take into consideration when this committee does the legal assessment of the national situation. So this is what this committee does on the basis, first of all, of the national report, plus in addition, all these comments that it receives. And this committee, the role of this committee in the reporting procedure is to decide whether or not the situation in a country is in conformity with the provision of the charter. So the conclusion that the committee issues is made per provision per country. So there are plenty of conclusions each year. At the end of the year, we have a lot of conclusions. And then as a follow-up, these conclusions are of course final, and they are legally binding, and they are communicated to the governments, of course, and then they are sent to the governmental committee of the charter. This can be a bit confusing now with so many committees, but just hang on there. I will try to be as simple as possible. So this governmental committee has the role to prepare the work of the Council of Ministers of the Committee of Ministers of the Council of Europe, which is the decision-making body of the Council of Europe. So the governmental committee, when it receives and reviews the conclusions, it is given an opportunity at a meeting in Strasbourg to provide oral presentations where they should say what has been done to bring the situation into conformity. But because there are unfortunately still a lot of violations, we have to select some of the cases for the governmental committee because they cannot go through all of them to present orally the position of the government. So most commonly we choose the cases of repeated nonconformity where country fails to meet its obligations for many cycles, or sometimes we have flagrant violations of human rights. These cases often get selected too. So the Committee of Ministers then, at the end of its meeting, prepares the report to be submitted to the Committee of Ministers, Governmental Committee to the Committee of Ministers, sorry. And then it is the role of the Committee of Ministers of the Council of Europe to recommend to the country, to the state concerned, what measures it should take to remedy the violation. I will just give you some examples later on of what recommendations the Committee of Ministers has issued. Well, unfortunately, in the past, the Committee of Ministers was not so keen on giving specific recommendations to states, but this has changed because we have started this reform process, and then we have done a lot of work to encourage the Committee of Ministers to issue such recommendations, because this is what they should be doing to follow up on the decisions of the European Committee of Social Rights. Just let me give you some examples. As I said from the previous cycle, sorry, there is a lot of text here, which maybe you don't see so well, but I will just walk you through it quickly. So last year, we had the provision on, we had the thematic group of things on, okay. The thematic group was health, social security, social assistance. These are the core values, of course, and core provisions of the Charter. And still here, unfortunately, there were many violations found. And I think that COVID crisis has also exacerbated the situation, because we're talking access to Article 11, access to healthcare, and then social security and the minimum levels of social security benefits. And with all these furlough schemes and all the misery that many countries and we all went through, unfortunately, the observance of these rights has maybe not deteriorated, but has not improved, unfortunately. And then there is also the right to social assistance, which is a very important Article 13 of the Charter, which guarantees a subjective right to assistance to any person in need. So all these issues were dealt with the European Committee of Social Rights, and in its conclusions, I have here, as you see, three points, and this comes from actually, that's also a part of the reform process that we started in 2019, that in addition to the national reports that states have to submit, they now have also to reply to the so-called targeted questions that the committee asks them. And these questions often concern most pressing issues in the society, emergent problems. And so like this, the committee tries to identify these issues and to address them, and possibly ask further questions with a view to developing its case law in the future. And so from all these questions, targeted questions that were asked in the previous cycle, these three issues were flagged by the committee. First is Article 23, it's the right of the elderly persons to social protection. Sorry, it's okay? Yeah, I'm very fast maybe, or it's okay, yeah? Yeah. Okay, sorry. In addition to what Article 23 already guarantees, the committee asked some specific questions about ageism, which is a big problem in our societies, unfortunately. So the committee asked the states what measures they are taking to combat ageism in society. So that would be in addition to adopting, of course, comprehensive legal framework that prohibits discrimination, not only in employment, but also outside employment, but in general, to encourage what they do to promote positive attitudes towards aging, and with a general view, of course, to prohibiting discrimination on the grounds of age. So that's ageism. Second was the so-called, it's a very interesting, it's a new topic also that committee has been looking at through its targeted questions. These are the workers in the gig economy, so-called gig or platform economy. You know that these workers can be very vulnerable because of their ambiguous status. Sometimes, well, they should be self-employed, but as it happens very often, they do have employment relationships. So in reality, they are not self-employed. So they are so-called false self-employed workers of bogus self-employed. And by having this ambiguous status, they often lose the benefits of the labor law protection. And in the case of this thematic group, the committee looked at Article 12, right to social security, so whether such workers have effective access to social security. So this was one of the issues. And the final one is that there's the right to disconnect, which is becoming more and more interesting, and some maybe a potential topic for developing the committee's case law. Is our start and when they end, and then it happens very often that workers do overtime, a lot of overtime, without it being counted as such and paid as such. So there is a potential abuse. So there should be the right to workers to refuse overtime work, or the right to disconnect from work should be also respected. So now let me move to the next slide. So here, this is maybe what could be very interesting for you are the examples of the follow-up that were given, that was given to the conclusions from 2021. Actually, I have marked them as recommendations to be adopted by the Committee of Ministers, because to tell you the truth, this is not yet done, because we are in the process. This is a cyclical process, so we are now getting closer to the end. So this has already reached the Committee of Ministers, and it will issue these recommendations. So I have 3 cases where the governmental committee and also now the Committee of Ministers decided to issue specific recommendations. Moldova, Azerbaijan, and Turkey. In Moldova and Azerbaijan, in both, there was a violation of Article 11.1, because in both of these countries, the infant and maternal mortality rates are very high. So the Committee of Ministers will recommend them to take measures to reduce these rates. In case of Moldova, there is also a general problem to access of healthcare. So that has been a repeated problem for Moldova. Unfortunately, there are big groups of population who basically have no effective access to healthcare. So this should be the measures to be taken, necessary measures to be taken to effectively guarantee this right. And in case of Azerbaijan, there is still a problem with prohibition of and sale of the use of asbestos, which is a big deal, and it should not be, of course. So the Committee of Ministers will also make this recommendation to Azerbaijan. And in case of Turkey, we have some violations of Article 3. That's also a very interesting article, right to health and safety at the workplace. And apparently in Turkey, there is no effective mechanism to monitor accidents at work and occupational diseases. And also there is no effective access to health services in all sectors of economy, of occupational health services. So this was very briefly about the reporting system. Now we move to a very interesting system, collective complaints procedure. I'm sure you know a lot about it. So let me just briefly say that in this system, and this is unfortunately not mandatory, it's optional. So it has only been accepted by 16, and we use every occasion to advocate, to promote this mechanism, because it is a very good mechanism for the states, and eventually all states parties to the charter, all 42 of them should adopt, and we're hoping that this will happen one day. So in this system, it's the complaints that are lodged by several different organizations, trade unions, employers organizations, NGOs, international NGOs, and where these organizations allege the violation of the charter. So, and then the Committee of Ministers makes a judicial assessment. So the procedure is very close to judicial procedure. So it decides whether, first of all, whether the complaint is admissible and well-founded, and then whether it decides on the merits, whether there is a violation of the charter. And here we have also a follow-up. I will later on give you some examples. It's again the Committee of Ministers that has the role of ensuring that situation has been brought into conformity. Now let me just say a few words in detail about this procedure. So complainant organizations, first of all, these are international organizations of trade unions like ETUC, and employers organizations who can lodge a complaint against the state, which of course has accepted the protocol, collective complaints. So only against 16 states so far, unfortunately. And it has to be on a matter that falls within the charter scope. Then we have INGOs. To be able to lodge a complaint, first they have to be included in the special list of NGOs that are entitled to submit a complaint, and secondly, they have to show that they have a competence, particular competence in the subject matter of the complaint. Then we have representative national trade unions and employers organizations. And then fourth category is the representative national NGOs. This category is, for this category to be able to submit a complaint, there should be a special declaration from the state when they accept the protocol, collective complaints protocol. So far only Finland has done so. Now, just a few words about the procedural flow. As you know, it's an adversarial procedure. First, well, first we register the complaint, and then we publish it immediately. Then there is admissibility, and then the president asks the respondent state for submissions, observations on admissibility, and then the complainant may respond, and then there is a deliberation, and the decision on admissibility is taken, and it's immediately published. Then we have the merit stage, where again there is this exchange of written observations, and there are time limits, of course, and then here we have possible third-party interventions, could be very interesting and very helpful, of course, for the committee, from social partners and so on. And then here we also have a possibility of public hearing. And at the end of this, there is a deliberation and the decision of the European Committee of Social Rights. For admissibility conditions, just very briefly, they are very simple, and we are very proud to say that for us, it's much simpler than for the court. For instance, there is no obligation to exhaust domestic remedies, which makes it very difficult, much easier for complainant organizations. And it's very simple. It has to be signed by person entitled to represent organization, and then of course it should be against the state having accepted the protocol, and it can concern one or more provisions. The complainant should indicate which provisions they are alleging, of course, a violation of which provisions they're alleging. And then if it's a national trade union, they have to be representative. And then they have these INGOs, they have to have particular competence, and then indicate why they think there is a violation. So they should give some evidence, of course. And then the merit stage, exchange of memorials, and sometimes it goes on and on can go for a long time, because there is an observation reply, further observation, and of course the government as a defendant has the last word. And then the committee sometimes can ask questions to the parties when it finds that where it finds that the things are not so clear. And at the request of one of the parties, there can be an oral hearing. There has not been so many, as you see. We have had only 9. And then, as I said before, third-party interventions are possible. Sometimes the committee itself asks for observations from other organizations, and deliberation and the decision. And the decision is notified to the parties and to the Committee of Ministers. When it is notified to the Committee of Ministers, it's still not public. So there is some strict rules to follow. But the respondent government is asked to submit information on what they have done to remedy the violation. And then this is where the Committee of Ministers decides to adopt a recommendation. Of course, these decisions are final, they cannot be contested. But it's up to the Committee of Ministers to adopt a recommendation. Unfortunately, in the past, we have not had many recommendations, but now they're becoming a rule. So it's been 2 years now that on every single violation, a Committee of Ministers has decided to issue a recommendation, and now we'll give you some examples. And then the decision on the merits becomes public when the Committee of Ministers has adopted a recommendation, and in any event, only 4 months after transmitting to the parties and to the Committee of Ministers. So there is this waiting period of 4 months for the decision to become public. And then finally here, I would like to say that we receive this question very often, whether or not the decisions and conclusions of the European Committee of Social Rights are binding. Yes, they are, because they are adopted by a monitoring body established by binding treaties. And the Charter is a binding treaty. And they must be respected. In any case, it must be possible to rely on the decisions and case law before national courts. And we have had some experience, as our speakers have already referred to earlier. We have had very good experience, some not so good maybe from France, but this is how it is. And finally, just a few examples of the follow-up of the decisions that could be interesting. First, I would like very briefly to say, because we can speak forever about this. It's a very hot topic. It's about equal pay. So our committee has adopted 15 decisions on this issue. So there were 15 complaints lodged by University Women of Europe against all states having accepted the protocol. Then back then we had 15. We didn't have Spain. Now we have 16 with Spain. So unfortunately, in 14 out of 15, a violation was found, even several violations. Only Sweden escaped. In Sweden, the committee did not find a violation. In all 14 of them, there was a violation. Different ones, but mostly the main bulk of violations concerned the fact that there is not enough pay transparency. So you know that equal pay guarantees should be guaranteed for equal work or work of equal value. So what is equal value? All this in some legislations are not defined well, and also there is no pay transparency in the meaning that this is what the committee said, and this is also what appears in the recommendation, that it should be possible for a worker to, in the context of judicial proceedings, of course, to request and obtain information about a pay of a fellow worker. So this is unfortunately not the case in many countries. So this is why there is a lot to be done in pay transparency in all these 14 countries. No, maybe not 14 of them, not all of them had a violation on this, but most of them, unfortunately. So this was one of the recommendations of the Committee of Ministers, to finalize adoption of measures to improve pay transparency. And as you may know, there is a directive of the European Union is trying to adopt a directive on pay transparency, and we're also hoping that that could also help, because all these countries against whom the complaints were lodged are very keen on adopting such a directive and being part of this directive. Then the second violation is the pay gap, the measurable progress, what the committee calls the measurable progress. As you know, for positive obligations and progressive realization of rights, what is very important that in a concrete and reasonable time frame, the state shows a measurable progress. Progress that can be measured, and in case of the pay gap, it has to go down. And it is true that in Europe, the pay gap is going down. The European average has significantly decreased over the 10 years, over the last 10 years, I must say. And so has it in several states, but maybe not in some states. It has become stagnant, unfortunately, and it's more difficult to reduce. So this is the recommendation, to reinforce existing measures aimed at reducing or eliminating the gender pay gap in order to show the measurable progress. And then the third one is the role and the share of women, and this it's still a big problem everywhere, even in all countries basically, well, apart from Sweden, obviously, that the representation of women in decision-making positions in the largest public listing companies. So still the share of women is very, very low. We have not looked at the CEOs, because in case of CEOs, it's a catastrophe. It's like 2, 3, 4% of women only. But here we're talking about the boards, management boards of large companies. And here too, it's going better. It's getting better because some countries take different measures. Some of them have introduced quotas. There is no obligation under the Charter to have a quota system, but it can be sometimes effective. So these were about UWE, University Women of Europe, UWE complaints. And now another example is from 2017 complaint against Belgium. Which was lodged by International Federation of Human Rights, FIDH. It's about children with intellectual disabilities and their mainstreaming in ordinary schools. And it turned out, especially in the French community in Belgium, not enough measures are taken. So there are lots of children who have not been mainstreamed. So the Committee of Ministers, on the basis of the decision of the European Committee of Social Rights, has recommended that necessary legislative and institutional measures should be taken to ensure that there is an action plan necessary conditions for effective inclusion in practice, and again, the measurable progress that the state must show. And also there is the measure, second recommendation is to take necessary measures to address the lack of permanent adequate monitoring to ensure the right of inclusive education and to protect children from discrimination. So, and my final slide is with some statistics. It's slightly out of date, I apologize, we just don't have more, more up-to-date information. It's just 2-3 months old maybe. So as you see, subject matter, when it comes to subject matter of the complaints, well, there is a wide variety because the rights of the Charter are very wide. 31 articles cover all possible social rights. But still the labor rights dominate. As you see, we have had 106 complaints about about labor rights, followed by children's rights and all the rest that you see on the screen. So this is the situation we have now. If you have any questions, I'm here. I will try to reply to you. Thank you so much for your interest. Thank you.
And this is now my turn to take the mic back. As Nino has explained, the role of the Committee of Ministers in ensuring the implementation of the rulings and the conclusions of the committee is extremely important because it puts political pressure on states to abide by what comes out of the committee. And to further this role, on the 25th of September of this year, the Committee of Ministers adopted a reform package, which is the result of a long process of reflection that started a few years back in Turin, actually. It was called the Turin process. The ultimate goal is, of course, better enforcement of Charter rights by states parties. And the main tenet of this reform is improved dialogue between the Charter organs and state parties. It was seen as being something that could indeed improve implementation. But there's also, I will start with that, there's also a novelty in the system, which is the possibility of what is called ad hoc reports. And this possibility provides a rapid reaction system where the European Committee of Social Rights will be able to tackle pressing issues outside the normal monitoring mechanism that is both the reporting and the collective complaints. So that gives it more flexibility to react to issues that are considered as pressing at a certain moment in time. And then the European Committee of Social Rights, together with the Governmental Committee, the Governmental Committee is a body composed of government representatives. It's kind of the anti-chamber of the Committee of Ministers in the Charter system. Will organize some follow-up dialogue with the states parties, but also with social partners and civil society organizations, etc. Now, the reform also has a big impact on the reporting system because my colleague explained, Nino, for the moment there are 4 themes and it works around these 4 themes, which means that it takes quite a while to cover all articles of the convention, which leads to, a big gap between the time one cycle is dealt with and when it's dealt with again. So now there will be only 2 groups of articles of about, I think, 50 provisions, which means that every 4 years, all the Charter will be covered, which reduces quite a lot the time frame. And it will pretty much be built around what has already started since quite a number of years on targeted questions, which will become the norm so that the committee really focuses on what is pressing now. Also, to increase the strength of the follow-up, the role of the Governmental Committee, which prepares the work of the Committee of Ministers, will be strengthened, and they will be adopting more recommendations than they have done in the past for adoption by the Committee of Ministers in order to trigger changes at the national level. Because again, the Committee of Ministers is the decision-making body of the Council of Europe, which can put pressure on states because there's kind of peer pressure that works there. And there too, the idea is to start a dialogue, meaning that the recommendation will not be, just punishment, saying naming and shaming a state, but it will be the starting point of exchanges, which can take various forms. It can take the form of exchange of letters with information asked by the charter organs or the Committee of Ministers. It can be meetings, it can be country visits, it can take all sorts of forms, but the idea is that the charter organs and the state parties work together to see where the problem lies and how it can be overcome. So that's one of the main benefits of this reform, which will start being implemented already to some extent next year. As regards the follow-up to collective complaints, now there are changes, but they're more procedural adjustments rather than the more drastic changes that I've mentioned for the reporting. As Nino has said, the Committee of Ministers fortunately adopts more recommendations in respect of decisions. And the idea is that now there will be only one single report on the follow-up by states parties after 2 years, 2 years after a recommendation has been adopted. And then the European Committee of Social Rights will assess this follow-up report and will transmit its findings to the Committee of Ministers. And depending on the assessment of the Committee of Ministers may decide either to close the case with a resolution if the situation seems to have been correctly addressed. It can renew the recommendation if things have not improved favorably. And before renewing this recommendation, it can also refer the case to the governmental committee for further consultation. So again, it's still government representatives that will engage in a dialogue with state parties to gather more information, which will lead eventually the Committee of Ministers to decide whether the procedure can end or should be renewed. So, as I've said, the main idea of this reform process is what we call enhanced dialogue between the charter organs of state parties. And it will also involve national human rights institutions, national equality bodies, trade unions, and other civil society organizations. And as I said before, it can take various guises. And the idea that, for instance, there would be country visits brings another more concrete element to the whole system, which will be interesting to see unfold. I think I'll stop here because we've given you a lot of information, probably more from our side than what is done afterwards in state parties. And that's something that we will be very interesting to hear from the different interlocutors that will speak today and tomorrow, because we don't necessarily have this sort of information. We have it sporadically, of course, and we try and follow it, but it's not something that is necessarily compiled as such. So we're very much looking forward to this discussion. So thank you very much.
Thank you for this excellent presentation that consider both what has been the European Committee of Social Rights and what will be the committee and the charter system. So we are really in a turning point. So the system, probably the necessity to change the rules because the effectiveness, as you said, need to be strengthened. So the committee realized that something should have been done in order to make the charter more effective. And on this topic, we have another presentation. Lorenza Mola, she is professor at the University of Turin, and she has just published a book on the European Social Charter. The title is La Carta Sociale Europea e il controllo internazionale sulla sua applicazione. That is more or less the Italian translation of the title of your presentation today. And so Lorenza will still talk about the charter system, but from outside, so not from the institutional point of view, but from the state party point of view. Thank you very much, Lorenza, for having accepted our invitation.
Thank you very much, Silvia,
for the invitation. I'm very happy to be here today. And yes, I will try to make some general thoughts on the control, the supervision of the implementation of the Charter by the state parties according to international law. So we know that supervision or control of subjects' conduct in a given system is a function which is exercised pursuing effectiveness of the rules of that system. So my broad question today is, how is effectiveness through control ensured to the European Social Charter at the international level? And in order to address this broad question, trying to zoom out from the Charter mechanism, I will divide my presentation into two parts. The first part will try to provide a reading of the appendix of the Charter. And the second part, on the basis of this reading, will consider other possible forms of supervision on the implementation of the Charter by the state parties beyond the Charter procedures, but always at the international level. So I will not deal with control, supervision of compliance of a party's legal obligation within the domestic system of that party. So why starting by the appendix? I take the appendix to the Charter as a starting point of my thoughts. By the way, according to Article 38 of the original Charter and Article N of the revised Charter, the appendix forms an integral part of the Charter. So I take this appendix because, according to the wording of part of the text we find in the appendix, it is understood, and I quote, so it is understood that the Charter contains legal obligations of an international character, the application of which is submitted solely to the supervision provided for in Part 4 of the Charter. So there is this solely submission to the supervision provided for in Part 4 of the Charter. So, according to this text, the treaty monitoring mechanism provided by the Charter, the reporting procedure, and later in time, the complaint procedure, appears to be the exclusive way of international control on the implementation of the Charter's obligations by the state parties. But does this understanding really have a totally excluding effect on other modalities of international control? What does this understanding by the state parties exclude? So a first remark to try to answer this question concerns the scope of this understanding. If you take the text of the appendix, you find that this text that I read, that I quoted, constitutes the first paragraph of the appendix to the Charter relating to Part 3 of the Charter. And Part 3 of the Charter consists of one single article in the 1961 Charter, Article 20, and the corresponding article in the revised Charter, Article A, which also contains Article B. But I will leave the issue of Article B aside for reasons of time and also because it could complicate things even more. So both Articles 20 and Article A are titled undertakings. So they regard the states parties' accepted provisions of Part 2. So you know, the a la carte system, so the accepted provision of Part 2, as well as the general commitment to pursue by all appropriate means the aims declared in Part 1, so with a wider scope encompassing all rights declared in Part 1 of the Charter. So if we think in the opposite way, this understanding does not seem to cover legal obligations which are contained in Part 4 of the Charter, those which concern the very mechanism of control, which is treaty-based, which has been set up by the Charter itself. The argument may follow, but I leave it open for now. The argument may follow that compliance with the legal obligations stemming from Part 4, so stemming from the very provisions of the Charter on the monitoring procedures, may be pushed through other international control mechanisms or modalities or means. I will come back on this point later, while now I would like to raise a second point on the possible contents of the exclusiveness character of this text of the appendix. Well, if we think of what could be excluded having regard to international control mechanisms, several hypotheses may come under consideration. So that solely understanding might be read to the detriment of domestic review of implementation of a state party of its international legal obligations according to the Charter. But this hypothesis so far has been widely discharged by both domestic practice and by literature, although, as you will see certainly tomorrow, the recent Cour de Cassation communiqué de presse seems to challenge that domestic review is possible according to the text of the appendix. At the international level, which types of reviews could come into relevance when considering the contents of the Charter and its context? Well, apparently the appendix seems to exclude all other means of supervision. In the legal and in the institutional environment of the Charter, however, relevant means of supervision of the application of the legal obligations of state parties would likely be several. So in our reasoning by hypothesis, if we think of interstate disputes, you all know that there's not an interstate procedure which is provided by the Charter. The sole supervision is the reporting procedure or the collecting complaint procedures. Does this text, this understanding of the appendix, exclude any interstate dispute about the interpretation or the implementation, the application of the Charter? And if we try to be even more general, does this text of the appendix excludes customary rules from applying? Think of diplomatic protection, or think of treaty-based consent to arbitrate, such as the one which is given by the contracting states of the Charter, which have also ratified the European Convention for Peaceful Settlement of Disputes, providing for the International Court of Justice, for example, to be competent to know about a dispute. But so far there has, to my knowledge, and I would really like to know whether I'm wrong on this, but to my knowledge, there has never been an attempt by one contracting party to the Charter at international supervision of the conduct of another contracting party against the Charter, against its legal obligations under the Charter at the international level. So far, there's no practice as far as I know. And in any case, this points to a very long-standing debate in international law on whether human rights treaties provide for self-contained regimes. So the procedures that are in those treaties exclude the operability of other international control mechanisms, such as those who would be available according to customary law. But I wouldn't limit this reasoning by hypothesis to customary rules or to interstate disputes, because there's also, and I will argue why, there's also room for considering treaty instruments. Within the Council of Europe instruments, this exclusionary understanding in the appendix could point to the judicial review of the state's conduct by the European Court of Human Rights. And vis-à-vis the ILO system, this understanding in the appendix might want to make it very clear that the supervision of the Charter does not rely on any sort of delegation to or integration of the ILO supervisory system for supervising the implementation of the Charter, or any direct involvement of ILO bodies in the control of the application of the legal obligations stemming from the Charter. I tend to think that this willingness to make it clear that both the European Court of Human Rights and the ILO supervisory mechanisms had to be excluded in the minds of those who drafted the Charter. Why? Because if you take the travaux préparatoires, which are really available on the Council of Europe's website, and if you read the debate that was engaged during the period of the preparation of the Charter, you note some interesting positions. On the one side, at the time when the Charter was drafted, so in the 50s, the conception was already firmly established at the international level that international protection of human rights, which was a new thing for the time, it was new because this was raised only after the Second World War. But in any case, at that time it was already clear that international protection of human rights implied both international recognition of human rights through provision of an internationally legal character and binding upon states, and also international control on the implementation of such legal obligations. So those who drafted the Charter wanted to introduce procedural provisions and procedures on supervising how the respect for norms that declared and recognized human rights at the international level was how respect was provided by the states. On the other side, if you read the travaux préparatoires, you see that it took quite a long time to those working on the Charter to finalize the mechanism. And so several solutions were put forward in early preparatory works and were finally dropped out. But since the very beginning, the idea that realization of economic and social rights by states required active intervention through legislative and administrative measures, discharged any proposal of justiciability, of having economic and social rights justiciable before a court, also at the international level. So any court system of adjudication was put aside, was rejected. Also, initial thoughts on relying on the ILO system, which was already in place for decades, were quickly discharged. But other proposals had been put forward that included, for example, the selection of cases by a charter-based tripartite body, excluding governments, associations of employers, association of employees, and civil society associations. And this in combination with a deferral of certain questions to the already existing European Court of Human Rights. Or, quite to the contrary, the exclusive involvement of the political institutions of the Council of Europe already in place, without creating any charter-based bodies. So you see, there is a reason why I think that the European Court of Human Rights and the ILO mechanism were in the mind of those who drafted this text of the appendix, which stresses the solely supervision of the legal obligations by the procedures provided by the Charter. And thus, at the end of this first part of my presentation, I will hurry up in the second part, I promise, I argued that, yes, of course, the Charter has its own treaty-specific mechanism, and at least this is true insofar as other treaty-based mechanisms are concerned and within the coverage, the scope of the text of the appendix, so undertakings. But at the same time, the system sometimes has proven not to be effective, and this is why there are so many efforts to improve the effectiveness of the system within the procedures which are established by the Charter. So my point would like to be outside of them and trying to see whether international law provides for other means of control for ensuring or enhancing the effectiveness of the Charter at the international level. So in particular, this could be relevant when we consider what happens after the termination of the two procedures which are provided by the Charter. So what if a state does not undertake conduct which is in line with the recommendations of the Council, or with even before the recommendation of the Council, Committee of Ministers, the Committee of Ministers, with the decisions or the conclusions of the committee? Is there any way at the international level to try to push the effectiveness of the Charter with regard to its implementation by state parties? And I say so because we have to take into consideration the European Committee of Social Rights has not been entrusted with the power to declare that a state which is found by the committee not in compliance with its legal obligations has violated the Charter, and thus is internationally responsible for this violation. And so differently from a court. And moreover, the Charter text does not explicitly provide the European Committee of Social Rights with the power to adopt binding decisions, and the final act of the whole procedure is a non-binding resolution by the Committee of Ministers. So this is what is not explicitly conferred upon the committee by the Charter's text. At the end, as the previous speaker has very effectively shown, there's a system of political peer pressure within the Committee of Ministers. So this does not mean, of course, the decisions and conclusions of the findings of the European Committee of Social Rights are authoritative, and according to certain legal theories, they should be considered as binding upon states. But taking all this into consideration, so my question is whether there is a way to ascertain, to declare at the international level that a state violates the Charter. Is there any kind of control available for this function to be accomplished internationally? So, but what is international control supervision? It's a huge issue, of course, but we must probably, for the purposes of today's discussion, be aware that international control may have a very, very broad and even loose meaning. It occurs in several contexts and takes different forms. So in its widened understanding, control may be exercised ex ante or ex post, and what comes first or after, before or after, concerns states' conduct in implementing a legal obligation and the violation of a state by a state of its international obligations. So as such, control, supervision also encompasses the domestic implementation of an international provision in the form of cooperation, for example, by international institutions in the Council of Europe with the state concerned, and assistance. Supervision also can occur through in political terms or on the basis of a legal reasoning. And what I would also like to pick up and to stress is that international organizations like the Council of Europe have an interesting control function. So the choice by states to organize their cooperation through the establishment of international institutions imply that these institutions are entrusted with certain powers of control on the members. So in the framework of the European Social Charter, international supervision was conceived and designed according to, in the light of a general conception at that time of the rights under protection, economic and social rights, as compared to civil and political rights, and of obligations relating to them. Now, much has changed since then, but that was the origin of the way of designing the reporting procedure in particular. But it was also quite influent on the monitoring, on the collective complaint procedure. So the supervision provided in the Charter, the treaty-based mechanism, was imagined as a means to enhance effective implementation of the Charter's norms at the international level. And this is why it is often called in the very first years of the preparatory works like international implementation, as if the Charter was implemented internationally. And in this perspective, international implementation of the Charter was seen as a means of international cooperation, aimed at accompanying states in the process of implementation at the domestic level. So with all this in mind, I come to my very last 3 points that I would like to make in the case of the European Social Charter on this very difficult question of whether there are other forms or avenues for international control when there is a treaty-based system providing for specific procedures, even in light of such apparently explicit text in the appendix on the understanding of state parties that that supervision is the sole one applying. So as I already mentioned, to my knowledge, there has not been attempt by a state to raise an international dispute or issue on the implementation of the Charter by another state, even though this could not be excluded if we only think of diplomatic protection, but if we also consider that the Charter, in my case, I do consider that the Charter has erga omnes partes obligations. However, most likely, in my opinion, international control on the compliance with the Charter takes place within the Council of Europe, and also within the statutory procedures of the Council of Europe. So even beyond what has been done so far and is now under discussion of a dialogue or a reinforced, let's say, dialogue and peer pressure within the governmental committee, with the support of the governmental committee and within the Committee of Ministers, when it acts according to provisions of the Charter. So I'm arguing that the statutory procedures that have a general scope within the Council of Europe may also be concerned as forms of international control on the implementation of the legal obligations of the Charter by the contracting states. Why so? Because the Charter is first and foremost a means of the Council of Europe to pursue its overall objectives, together with the European Convention of Human Rights. The Council of Europe is involved in the, let's call it generally, management of many Charter-related activities. It is involved in treaty drafting. It is involved in treaty implementation through the procedures that we have considered so far, so the treaty-based procedures. It is involved in discussing reforms of the Charter system, in proposing reforms, but even more broadly, in discussing reform of the entire human rights system within the Council of Europe. And moreover, in the context of the Council of Europe, there is a duty of sincere cooperation of states with the organization. And this might trigger the ordinary or the statutory procedures of political control on states which do not abide by their legal obligations under the Charter, especially as regards the Charter-based procedures. So after the termination of a certain procedure, if states still do not put their domestic legislation and their conduct into compliance with the Charter. So I thank you for your kind attention. These were my last points that I would like to raise in the light of the text of the appendix. Thank you.
Thank you very much, Lorenza, for this brilliant presentation. And yeah, I think, of course, I'm a labor lawyer, so I'm not a specialist in international law. But while you were talking, I was thinking about the fact that the International Court use the quasi-jurisprudence or jurisprudence of the other international body. So, for example, the European Court of Human Rights use very often the decision of the European Committee of Social Rights. And this is probably currently the most important way to strengthen the Charter and to reciprocally build an international order. The only problem is the Court of Justice. So the Court of Justice basically ignore it doesn't ignore the European Social Charter, of course, because it's not possible. It's mentioned in the Treaty on the Functioning of European Union, but ignore, as far as I know, until now, the quasi-jurisprudence of the European Committee of Social Rights, and this is a problematic issue. So this is currently a problem. Anyway, we're just, a consideration. Now we start with the second part of our seminar. So we start looking at the national legal order. So we inverted this perspective. We want also to check what is going on in the state parties of the charter, and we start from Portugal. We have with us online Catarina Santos Botelhos of the Catholic University of Portugal, Lisbon, and she will talk about the effectiveness of the European Social Charter in Portugal. Catarina, the floor is yours.
Thank you so much. I hope you can hear me well. I have a PowerPoint to share, and I'm sorry that I have not sent it previously. I don't know if I am able to do that. I will try to see if, well, because I never used this. So let me see if I can share the screen. And now, if you can see the PowerPoint, I'm not sure if you are able to see it, but I hope you are. So I will address the application of the European Social Charter in the Portuguese legal arena, more specifically by the Portuguese courts, the Constitutional Court and the Ordinary Courts. But before doing that, I have to very briefly explain how is the Portuguese judicial review system, which peculiarities of the Portuguese legal order might explain why the charter is or is not being well implemented. So the distinctive traits of Portuguese constitutionalism are, first and foremost, we have the longest unamendable clause in the world. This means that we have a really long list of subjects that cannot be amended, even if all deputies of the parliament within a constitutional amendment process want to amend those issues. So this is the long list. In green, I have highlighted some subjects that are perhaps not, well, that could not be perhaps eternity clauses or these unamendable clauses, but that are enshrined in the Portuguese constitution as unamendable clauses. So you see the list is really long. We still have an economic constitution. So we have several articles that are related to the economic constitution, although perhaps some of them were kind of, some explicitly and others perhaps in a more tacit way amended by the European integration. And we have, and this is very important, a very prolix catalogue of social rights. Social rights are enshrined in the Portuguese constitution as fundamental rights. So they are not principles, they are rights, they are fundamental rights. There is, although social rights are enshrined as fundamental rights, the Constitution has a kind of distinctive way of treating liberty rights and versus social rights. Perhaps, and this comes from the influence of the international arena, where you have the European Convention on Human Rights, and then the European Social Charter, and perhaps this schism was reflected in the Portuguese Constitution, and the fundamental rights were divided in these two categories. That although these rights have the same, worth and dignity, the regime is different and is more beneficial towards rights, liberties, and guarantees because they are self-executing norms, and social rights are non-self-executing norms. still the Constitution has a kind of a way of how do I explain this, to upgrade your social, economic, and cultural rights norms into the same regime as the rights, liberties, and guarantees. And this is through Article 17 that you can see there in the PowerPoint, when these rights have a similar nature to rights, liberties, and guarantees. And this was already considered several times by our Constitutional Court. Having said that, I have to say that the Portuguese Constitution grants the Portuguese Constitutional Court a wide range of judicial review powers, even though we don't have a constitutional complaint mechanism. The PCC, the Portuguese Constitutional Court, is a cosmopolitan court. It does not hesitate to engage in comparative constitutional law. It often cites foreign constitutional courts and international and foreign scholarship. However, the European Social Charter has not had a significant impact on the Portuguese constitutional jurisprudence and in the Portuguese jurisprudence consider also the ordinary courts. And now I will follow an article that I have written with also with Manuel Fontaine Campos and Bruno Mestre, to the first volume of the commentary on the European Social Charter, and the title is The European Social Charter's Applicability by National Courts. And so I will focus on the question of Portugal. So the Portuguese Constitution has very transparently conferred direct applicability on treaty provisions. So one should expect a wider impact of the European Social Charter. But quite frankly, that is not the case. So constitutional jurisprudence, we have, I have selected three rulings. In this first ruling, the Portuguese Constitutional Court preventively analyzed legislation that would widen the grounds on which the contractual public employment bond could be terminated for objective reasons. The Portuguese Constitutional Court then emphasized that the relevance of the prohibition on dismissal without just cause derives from its condition as a public European law principle enshrined in Article 24 of the revised Social Charter. So this is obiter dictum. Again, obiter dicta, rulings 328 and 583, as the PCC referred to Article 25 of the revised Social Charter regarding the protection of effective exercise of the right of workers to the protection of their claims in the event of insolvency of their employer. We can also find references to the European Social Charter within dissenting opinions. So differently from what happens within the Italian, for instance, constitutional justice system. In Portugal, justices can have dissenting opinions. We have concurring opinions, dissenting opinions, and these dissenting opinions are public, and you can clearly see which judge has voted favor or against and why. So in this ruling, 612, Justice Mariana Canutilho considered that constitutional social rights norms should be interpreted in consonance with European Union law and international law. So the right to housing, which is enshrined in Articles 30 and 31, ought to be granted in the widest extension possible, given its intrinsic connection with human dignity. I think this is relevant to mention. Now, if we look at the jurisprudence of the ordinary courts, we will see something similar. The decision of in 2015, the Supreme Court of Justice had to decide on the legality of an unlawful terminated open-ended employment contract, which was followed by the conclusion of a fixed-term contract between the two parties 6 months later. The legality of the fixed-term contract was not questioned. the court decided that the second contract had implicitly revoked the first, even though the first was unlawfully terminated. But what was important, and that I have to emphasize here, was that the court then added that this interpretation did not violate Article 1, number 1 of the European Social Charter, since the national statute makes the conclusion of a fixed-term employment contract dependent on the number of preconditions in order to avoid abuse. So the legality of the fixed-term contract was not challenged in accordance with the Portuguese law. Furthermore, and since the worker maintained the right to compensation for unlawful dismissal, the court concluded that there had been no violation of the rights enshrined in Article 1, number 1 of the European Social Charter. So this time, the court, this is not a citation obiter dictum or obiter dicta. This was a clear dialogue with the European Social Charter. So this decision is relevant. Again, in 2018, the question concerned the conformity of Article 2, number 5, of a situation in which a company's shift work was organized in such terms that the worker was obliged to work for 12 consecutive days, followed by a rest period of 2 consecutive days. The court, again, the Supreme Court of Justice, affirmed the legality of such an arrangement in accordance with Portuguese law by invoking the European Court of Justice judgment, Marques da Rosa, together with the decision of the European Committee of Social Rights, both expressly allowing for such an organization of working time. The court invoked the Article 8, number 2, the one that I've showed you in the beginning, and expressly stated that conventional international law, that is international treaties, is not only binding in the Portuguese legal order as an autonomous source of law, but also has a supra-legal dimension, being capable of setting aside conflicting national norms. So the European Social Charter might be beneath the Constitution, but is above the legal arena, the ordinary, let's say, legal arena. And although the Supreme Court did not expressly state that the European Social Charter was one of those norms, it appears to be legitimate to conclude from the reading of the text that it might be the case. So the binding character of the charter is not expressly stated, although it is implicit. It appears to be assumed when it conflicts national norms. Why is, if you go to the websites of our courts, of the Supreme Courts or of the constitutional courts, and if you write, for instance, European Convention on Human Rights, thousands of citations will appear. But if you write European Social Charter, that will not be the case. So such parsimonious citation of the European Social Charter could be justified. We could think, oh, because the Portuguese constitution has such a long list of social rights, then we can understand why the European Social Charter is not cited as often, or it is more obiter dicta. Well, this could be an explanation, but we found also that there is quite a discrepancy between the citations of the European Social Charter and the European Convention on Human Rights. Thus, this sparse citation of the Charter is not a matter of aversion to international law, because in the Portuguese legal thought, there is really no aversion to international law or to comparative law. We are completely open to comparison of other constitutional orders. We are completely open to cite international law. I think the problem is really more serious and more profound, which is a wider problem, not only of the Portuguese legal arena, but perhaps a European problem or a global problem, which is the place of social rights within the legal arena. What are social rights? What they and citing a Brazilian scholar, I'm thinking about Professor Ingo Wolfgang Zarlet, when he wrote that the problem of social rights is a problem of identity. He wrote this in Portuguese, but the idea was that he was trying to sum up the problem of social rights. And I quite agree with him when he says this is a problem of identity. And this identity is not only qualitative identity, so how are social rights designed? Are they designed within norms that consecrate fundamental rights, subjective rights, or are they only merely principles or objectives or norms that are not self-enforcing, or programmatic norms, for instance? Or are they not even norms? So the problem is of the qualitative identity, and also about the quantitative identity, so the quantum of protection. And this varies completely within the European Union arena, within the Council of Europe jurisdiction. So I think that in Portugal, as well as in several other constitutional orders, the European Social Charter is echoed sotto voce, which means that, okay, it is not completely silenced, but it is not in the same place as other international legal instruments. And why? Regarding, so, and just to end my communication, and now I will focus more in Portugal. What are the reasons behind such discrepancy in international regional instrument citation? Why is that the European Court of Human Rights is very heavily cited, and the European Social Rights Committee is not? So there must be a reason for this. We could think that regarding Portugal, the problem would be that if we have a really long list of social rights, and social rights are enforced in the Portuguese constitution as fundamental rights, well, we don't kind of need the international protection that much. We don't need to cite the international source, because we have the internal source. So people can grant their rights through national sources and don't need to invoke international sources. But that could be a circular argument, because we could think that we can use the same argument towards liberty rights. So I don't know if this makes sense, this argument. And then the fact that Portuguese law schools, scholarship, and justices are not familiar with the European Social Charter. And I think this is very true in older scholars, but in not so older or more senior scholars. Even in young scholars, they know something about the European Social Charter, but oftentimes there is even a confusion about what is this European Social Charter? Is this a regional international instrument, or it has something to do with the European Union? So there is some ignorance regarding this instrument. I think that more awareness is needed regarding the place and the relevance of the European Social Charter. And just to end, the likelihood that several justices might consider the European Social Charter, and wrongly, as we have heard before. So, of course, the European Social Charter is not a soft law instrument. It is a hard law instrument. It is binding. But I think that there might be this perception that the European Social Charter is kind of a soft law instrument, and therefore is not immediately enforceable. And so if this is not a hard law instrument, then perhaps this might explain why it is not cited as often, and why there is not as much scholarly effort towards studying and teaching and learning about the European Social Charter. So just to end, I think that more should be done in order to make the European Social Charter and to present to our students and to our scholarship the European Social Charter as a valid instrument and as an international instrument that is very relevant. It is relevant in countries that have a wide list of social rights, and it is relevant in countries that do not have a wide list of social rights. But having said that, I don't think that the European Social Charter is silenced. Even today, I was just reading that Federal National Association of Teachers in Portugal endorsed the constitutional complaint regarding Article 3 and Article E, non-discrimination, of the revised European Social Charter, because it alleges that the Portuguese government violated these provisions when the Portuguese government modified the sickness mobility scheme for teaching staff, allowing teachers suffering from incapacitating illnesses or when their dependent family members suffer from this very incapacitated illness, to be posted to a school close to the place where medical care is provided. So what happens now in Portugal is that in public schools, the teachers each year they have to apply, and they can be located in a school that is 200 kilometers away from their home. So previously there was an exemption to teachers with incapacitated illnesses or when their families have these illnesses, but the legal regime changed, and so they are arguing against this. So this is an example that the European Social Charter is alive in my country, and this is relevant. But even so, I think that much more work needs to be done in order to have a true, indivisibility between liberty rights and social rights. I don't believe that social rights are important because they belong to a political ideology. I don't think that any political ideology should claim social rights as their rights. I think that social rights are important because they belong not to politics, but to human dignity, and therefore they should be enforced and well enforced in our states. Thank you so much for this opportunity. Thank you all.
Yeah, I start again because people online couldn't hear me. So thank you, Catarina, for this presentation. And I was commenting that not only Portuguese scholars do not know the European Social Charter, but the Italian scholars as well. And this is a huge problem. And I was just adding an example that happened to me. So during a conversation, a discussion with some labor lawyer, some colleagues, we were discussing about the fact that the Italian dismissal law does not respect Article 24 of the European Social Charter, and half of the people there understood that the Italian dismissal law didn't respect the Article 24 of the Italian Constitution. So there was a huge misunderstanding. Then we clarified that we were talking about different text, legal text, but just to provide an example that even among labor lawyer, the European Social Charter is not very well known, and I think it should be used in order to enhance the national constitution. So really, the idea is that the European Social Charter should be enforced through the national court, because I think that this is the only real way to make the European Social Charter alive, to give it effectiveness. Anyway, we have ended the first part of the meeting, so now we have a coffee break. Thank you to all the speakers, and so we can go down for the one in presence, not for the one offline, of course. We can go downstairs, and we have a short coffee break, so we will be here in 20 minutes, Ilaria? Yeah, 20 minutes. Okay, thank you very much. Ciao.